Hi, I'm Travis Luther, and with me today are the attorneys from Watson and Associates. You know, contrary to popular belief, the federal government is not immune from suits when it is in breach of its agreements. Innate in every contract, including those entered into by the federal government, is an implied duty of good faith and fair dealing, which encompasses the duties to cooperate and not hinder contract performance. With me today is attorney Joanne Rupprecht of Watson and Associates, a law firm specializing in federal government contract matters. Joanne, thank you for being with me.
Thank you for having me.
So, how do most claims against the government originate?
Well, as with any dispute between two parties, many times it's just informal expectations or some type of imbalance in the power between the two parties. So many times in federal government contracts, when there are changes or modifications which occur after a contract is entered into, and if those changes and expectations are not formally captured somewhere in documentation, many times disputes can arise with regards to those types of situations.
So what connection do modifications have to terminations?
Well, many times when the government requests more of a contractor than what's actually contracted for, and there are scheduled delays or additional expenses incurred by the contractor, many times disputes will arise that may lead to terminations, termination by the government. And the government can terminate either on the basis of its convenience or on the basis of default of a contractor. So many times when there are these disputes that come up, they can oftentimes lead to terminations by the government.
So when there is a disagreement over a contract's terms, how is it usually resolved?
Well, normally you go to the actual terms contained within the document. The government always drafts its own contracts, and so the government is the best source to go to for interpretation. But in the event there are ambiguous terms, then many times all it takes is some sort of constructive dialogue. Either the contractor can do that themselves, or many times it's advisable to get an attorney involved.
Mm-hmm. And so what are the venues available for contract interpretation disputes?
Well, again, you always want to go to the primary party, and so that would be the agency responsible for that contract. Go to them, the contracting officer who has absolute authority with regards to how that contract is interpreted and implemented. They're always the best source for any type of interpretation. If that doesn't work, then many times you can go to the contract boards of appeals, either on the civilian side or the armed services side.
Mm-hmm. And is that the extent of what a contractor can do if they feel like they've been wrongfully terminated?
Yes. Well, many times these types of claims, these types of disputes are successfully resolved at the agency level. Upon filing of a claim, an agency has 60 days with which to make a determination. In the event within that 60 days there is no determination, the claim can be deemed denied, and the contractor has a right then to go ahead and elevate it to those armed services boards of contract appeals or the civilian.
And then so at your law firm at Watson and Associates, how do you go about recovering for losses?
Many times the principles employed are breach of contract. Mm-hmm. One of the parties has breached a contract. Many times it's for non-payment of a claim. There's been some sort of breakdown within the implementation of the contract at the agency level, and many times it just takes opening up the doors of communication to get resolution and to get payment to contractors.
Mm-hmm. And is there anything else that we haven't covered that you think is important for business owners or contractors to know?
I think it's important that contractors understand that the terms of a contract dictate what the requirements are, what what the expectations are of the government, and what expectations they should have as well. If it's not captured in a contract, absent a change order, absent a formal modification, the contractor should reserve acting upon simple requests of the government. It should be captured somewhere in the documentation so that the contractor's rights are protected.
Thank you, Joanne. Appreciate you coming down. If you are a business owner seeking to do business with the government, or you already have, and you feel like you've been wronged and have a dispute, I would encourage you to reach out to the law firm of Watson and Associates. They can be reached by phone toll-free at 1-866-601-5518, or visit their website at theodorewatson.com. Again, Joanne, thank you so much for being with us.
Thank you, Travis.